Hello everyone, welcome back to Veranda IAS. We will continue our session of Polity Foundation course from the next topic, next session today, that is previous year question paper analysis. We were actually trying to find out the types of questions and how to tackle these questions asked in UPSC prelims with the means of some of the previously asked questions. We'll continue that session with 7 more questions today and we'll try to examine that how to approach different types of questions, what should be your preparation strategy so that you can fetch more and more marks. So very first question of the day is, which article of the Constitution of India safeguards one's right to marry the person of one's choice? Prelims 2019. When it was asked in 2019, it was a very new question at that time. Why? Because right to marry a person of one's choice was never mentioned in any of the books then. Although, from where did this question was asked? This question was asked from the current affairs. 2018 Hadia case, Supreme Court gave this verdict that right to marry the person of one's own choice is a fundamental right. Now, under which article it is a fundamental right? Following were the options 19, 21, 25 and 29. If you know the articles of the fundamental rights, then you can easily eliminate at least 2 of these options. Okay, we'll go ahead, we'll see how it ended up being a part of which article. Basically, it is Article 21 of Indian Constitution that deals with right to life. Very, very important, right to life is granted as a fundamental right to all the people under Article 21. So basically, in Article 21, with time and again, Supreme Court has has given a long list of articles covered under Article 21. It also includes right to have a decent standard of living, right to have food, right to even sleep. It is also part of right to life. So under this article only, right to life, Supreme Court declared that the right to marry the person of one's choice is under right to life as a fundamental right. This is what was asked in 2019. So with current affairs, questions come like this. It was very new question for the aspirants of that time. No book contained the list of contained right to marry the person of one's choice in the list of rights given by them. So its right answer is option B, Article 21, right to life. Second, consider the following statements. First, the 44th Amendment to the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. First and foremost, 2 terms are there, judicial review and judicial activism. You have to understand these terms, very, very important. You have to read these. So we'll discuss this question as of now. 44th Amendment Act. What it did? It added an article that says that the election of Prime Minister of India is beyond judicial review. What is judicial review? If any law is not in congruence with Indian Constitution, it can be challenged in a court of appeal, in a court, that is Supreme Court. So basically, judicial review is the power of the courts to check whether the law is valid or not. So this statement says that the Prime Minister's election were made beyond judicial review by 44th Amendment Act. Actually, this was done, but not by 44th Amendment Act. It was done by 39th Amendment Act. Not 44th, but 39th. So what takeaway we have from this? Even the amendment acts with important provisions become important. So some of the factual information you need to keep in your mind. Second statement, the Supreme Court of India struck down the 99th Amendment to the Constitution of India as being violative of independence of judiciary. To get this statement correct, we need to know 99th Amendment Act. What is 99th Amendment Act? It was basically a system of appointment of judiciary. It was removing collegium system. The appointment of judges was done by collegium system. The people inside the judiciary only decided who will be the next judge or the next judges. So basically this act attempted to take this power of appointment of members of judiciary from the judiciary and incorporated the power in the central government or the parliament. So this act was considered as, this amendment act was considered as considered against the independence of judiciary and was hampering the powers of judiciary to appoint their members. So judiciary, what Supreme Court did? Supreme Court nulled down this act. Why? Considering that it is violative of independence of judiciary. Now, why these two statements are asked? Because this power of Supreme Court is under judicial review. This power of Supreme Court is under the provision of, is enjoined by the provision of judicial review. So basically that is why these two statements are being asked. This was the question which was asked in 2019. That time this 99th Amendment Act was in news time and again. Like all the newspapers had discussion that what will be the pattern of selection of the judiciary members from now onwards. So that is why this question was very obvious. What were the options? 1 only, 2 only, 1 and 2 and neither 1 nor 2. Correct answer is statement 2 only. That 99th Amendment Act was nulled down, was cancelled by the judiciary. Next, question 3. With reference to the Constitution of India, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which of the following? You are given a very lengthy, long, complicated sentence and UPSC has asked you to explain what we have given to you. 2019 prelims. To understand this, you have to read this question twice, thrice, maybe 4 times. Depends on your understanding. Then Article 142. You have to know, you need to know what is Article 142. Then only you can solve this. What are the options given? The decisions taken by Election Commission of India while discharging its duties cannot be challenged in any court of law. Do you think there is any talk about Election Commission in this question? No. What the question says, with reference to Constitution of India, prohibition, limitation or provision contained in ordinary law cannot act as prohibition, limitation on the constitutional powers under Article 142. First of all, if you know Article 142, you will be able to solve. It has nothing to do with the Election Commission, but Article 142 is about the judicial review powers of Supreme Court. So basically nothing to do with statement 1. Second is, Supreme Court of India is not constrained in the exercise of its powers by laws made by the Parliament. Third, in the event of grave financial crisis in the country, the President of India can declare financial emergency without the counsel from the Cabinet. The provision of financial emergency is discussed in Article 360. 3 types of emergencies are there, Article 352, 356 and 360. So financial emergency is in Article 360 and not Article 142. Then last, state legislatures cannot make laws on certain matters without the concurrence of the union legislature. Article 142 also is not dealing with the state legislatures and their powers. If you just know the content of this article, you can easily solve it out. Even you are able to understand the complicated statement or not. It was also asked in 2019 and also then Article 142, the judicial review power of Supreme Court was in news all the time throughout the year. So its right option is option B. The Supreme Court of India is not constrained in the exercise of its powers by laws made by the Parliament. If any law made by the Parliament, Supreme Court finds out it is not in congruence with Constitution or some other need to make it null and void as per the provisions mentioned in the Constitution, Supreme Court has full authority to do it. We'll discuss next which one of the following suggested that the governor should be an eminent person from outside the state and should be a detached figure without intense political links or should not have taken part in the politics in the recent past? Asked in 2014. It is asking which states, like which of the following states, that governor should be a person from outside. Now what is asked? These are some committees, some commissions whose names are given in the options. Now what I want to convey to you through this question, why I have included this question, is even when we are preparing any subject, what we do, we generally ignore the committee's recommendations. What we do, it will be a part of mains. When we are writing the answers, we can include these there, and there is no need of including it here. So generally, whatever approaches, we will ignore its recommendations. But even recommendations are being asked in prelims. We cannot afford to ignore those. So basically, it was Sarkaria Commission under under retired judge Ranjit Sarkaria, formulated in 1983 on the matters of center-state relations. Since governor is appointed by central government in the states, it has given a lot of recommendations on the working, appointment and management of the post of governor of a state. So basically it was given by Sarkaria Commission. Sarkaria Commission is very, very, very important topic. Next, we'll move ahead. With reference to election of President of India, consider the following statements. There are two statements, factual information. Just when you are reading the chapter of President, you will find it out. The value of vote of each MLA varies from state to state. Second says, the value of vote of MPs of the Lok Sabha is more than the value of vote of MPs of the Rajya Sabha. Now think, even if you do not know anything, from state to state, the value of vote of each MLA can differ or not. If it is differing, what will be the situation? If not, what will be the situation? If it is not differing, a very small state like Assam will be having same number of members like the very large state of Uttar Pradesh. So basically it should differ, and it differs as well. The value of vote of MLA, member of legislative assemblies, differs from state to state. Why? To give proper representation to the populations of the state. Some states are large enough, have more number of people as residents. Some are small enough. So basically, to overcome this difference, to give them proper representation, the value of vote of MLAs differ. Second is the value of vote of MPs of Lok Sabha and Rajya Sabha. So Lok Sabha and Rajya Sabha are two houses of parliament. Their value does not differ and should not differ. So then only we can assure the proper representation of people of different areas in the parliament. Which of the following statements given above are correct? It was asked in 2018. Correct statement is being asked. So we know option 1, 2, both 1 and 2 or neither 1 and 2 are the options given to you. We know the answer. The answer is option 1 only. After this, we will see the next question. Question 6. If the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, then what happens? Asked in UPSC Prelims 2018. Right now I told you it is 352, 356 and 360, which deals with 3 types of emergencies. So under Article 356, Indian Constitution gives the provisions of state emergency. So if the President of India is exercising his power in the matter of a state emergency, that is under Article 356, what will be his actions? The assembly of the state, or what will be the way ahead? The assembly of the state is automatically dissolved. The powers of the legislature of that state shall be exercisable by or under the authority of Parliament. Article 19 is suspended in that state. The President can make laws relating to that state. I have tried to bring you questions from different parts of syllabus so that you can understand what all questions we get from different topics. This is from emergency provisions. So basically you are being asked what is the emergency provision. Like if emergency is enacted under 356, what will be the next step? What will be the structure? Its right answer is option B. The powers of the legislature of the state shall be exercisable by or under the authority of Parliament. It means the Parliament of India will start ruling that state, will start governing that state. Governing is a better word. Will start governing that state, and the state legislature will get dissolved, or the powers of the state legislatures will be taken over by Parliament of India. This is what is done under Article 356. We'll move ahead. Also, this question was asked in 2018. 2018 had a lot of cases of these, like a good number of cases of this state emergency. That is why this was asked. Next is question 7th. Which one of the following statements about the duties of Prime Minister is correct? Okay, 1996. Why so old question I have included. It is not asking you about the powers of the Prime Minister. It is not asking you about the constitutional provisions. It is asking about the duties of the Prime Minister. So this becomes important. This type of questions are also being asked. What are the options given? Is free to choose his minister only from among members of either House of Parliament. One thing more, there is a easy way to crack prelims. Words like only, like only after this and only this, all these phrases which are extreme in nature, like giving you a definite thing, generally those statements are incorrect. You can, when you will solve more and more questions, you will be able to identify. But these type of words, only after that, only after this, like the statements which are giving you a definite condition, those are generally incorrect. So this is incorrect. Is free to choose his minister only from among the members of either House of the Parliament. Prime Minister is free to choose the members of his council even before, like even outside the members of the Houses of the Parliament, that is Lok Sabha and Rajya Sabha. Can choose his cabinet after consulting the President of India. No role of President is there. President is even appointed, like informally, President has some or other influence of the ruling party, the Prime Minister. It is not President who gives consultation to Prime Minister in choosing the members of his ministry. Third is, has full discretion in the choice of persons who are to serve as ministers in his cabinet. And fourth is, has only limited power in the choice of the cabinet colleagues because of the discretionary powers vested in the President of India. This is not a discretionary power of the President of India. Since Prime Minister is the ruler, is the leader of the ruling party, he has this authority that he can choose his ministry, his members, and he has full discretion in the choice of persons whom he want to include in his ministry. So option C will be the right answer to this question. This was all about the questions being asked in prelims in previous years. I hope you have a better understanding of syllabus now and how to tackle different parts of syllabus, how you get questions from different part of syllabus, and how you have to solve these different types, varieties of questions. We will continue from here. In another session, we will continue and discuss about the questions asked in mains. Till then, stay tuned, keep studying. Thank you so much.